Ready? Start. In respect to the exercise of dropping of the proceedings or the decision to refer the matter to the disciplinary committee, it is the prima facie satisfaction of the Bar Council on a perusal of the complaint and details so furnished by the complainant, and if that satisfaction at this stage is tested in the light of the defense slash evidence which might be placed before the advocate concerned, then it may lead to a situation that in all reference matter, this court, as the fact finding court, is to find out the correctness or otherwise of the decision and then to accept or not to accept the decision of the bar council and then leaving it to be just tried by the disciplinary committee. Full stop. This may be in the and then interest of the concerned advocate also, for the simple reason that if dealing with the factual aspects in the light of claim slash contention of both the sides, comma, if this court found the contention of the petitioner to be not acceptable and feels the case to be a fit case in which reference has been correctly made, which is to be tried by the disciplinary committee, then that may cause prejudice to the concerned advocate, which he may complain at a later point of time. Full stop. Thus, it is always safe for the court and also for the concerned advocate to permit the defense to be placed before the disciplinary committee and also the evidence so that the merits in the case of either of the sides may be judged and appropriate orders, comma, in accordance with law may be passed. Full stop. The aforesaid situation may be placed in another way, that is, in respect to any kind of charge either against a government official or otherwise, comma, if proposed allegation and charges are communicated to a person and he is called upon to submit his reply and the material in support of his version, then he is to do so instead of insisting for non submission of the reply and the materials in support of his version. Full stop. It will be wrong on his part not to satisfy that authority by filing response, rather rush to this court for investigation of the matter as a fact finding court. Full stop. If the matter is attended by the court, then certainly other side is to be called upon and for accepting slash rejecting merit in the contention of either of the sides besides the exchange of pleadings. Evidence will also be required and the writ exercise especially is not meant for this. Full stop. The court will have to refuse to accept the submission of the petitioner's side. Full stop. As on date, the matter having been referred to the disciplinary committee, a notice from the committee for filing of the defense and the evidence by the petitioner will be just a procedural matter and thus insistence of the petitioner that it should be undertaken by the bar council itself, which consists of 25 members, appears to be totally unjustified and that is not acceptable. Full stop.